Welcome to the Wills and Estate Transmission Podcast, brought to you by De Groots, specialist lawyers in wills and estates.
Hi, welcome to the Wills and Transmission Podcast channel with De Groots. And today we have Julia Tutt joining us. How are you, Julia?
I'm good, thanks, Tony.
Excellent. And there's a reason it's your first time with us because you're still fairly new with the company.
I am. I started in May and I'm very happy to be here.
Thank you very much. So we're covering off on a key topic about power of attorney and so forth. So let's start off with what actually is an enduring power of attorney.
So an enduring power of attorney is essentially a document that you, the principal, appoints an attorney to act in relation to your financial affairs. This document is used while you're alive. So people often get confused between this and a will, or they think that the power of attorney will have effect after someone dies, but that's not the case. So it's about only in relation to their financial affairs while they're alive, and they may or may not have capacity, and that's where it comes into effect. So people often, they hear about the term an enduring power of attorney. The term enduring, a good way to think about it is that it endures after you lose capacity, if that's the case. So it's a very, very, very important document. It's often the document used by adult children to help their parents in their older age, where they might have lost capacity, they might have dementia, they might have different health issues. So it's a very, very, very powerful document because it gives attorneys access to people's money, and it's a very important document. I know that I say that a lot, but it really, really is, and we're noticing, and the statistics reflect that so many people don't know what the document is. They're not getting legal advice when they sign it. Yeah, they get confused, which is also it's very fair to get confused about these documents. This is only, in New South Wales, this is only one of 3 main documents. So they get confused, and that's fine. But there is that lack of knowledge about the documents and therefore the power that the documents have. And so the enduring power of attorney in relation to finances in today's society in Australia, with the largest transfer of generational wealth just starting to occur and only going to increase, that dynamic in our community is reflective in the documents and how powerful they are. It's just it's a crucial document in someone's estate planning. I think people don't put enough weight on the document itself and consideration into how it may be used.
Yeah, it's interesting what we were talking about, how important the document is and what effect it has on people. I thought of, it's like being put into a childlike state. When you've got little children, you're fully responsible for them and there's nothing they can do, and it can put you in the same sort of position.
Yes, that's often, unfortunately, an example I use when people are putting into effect a different type of document, which is an enduring guardian, and that's about medical and lifestyle decisions. It's about where you live. It's about consenting to medical treatment when you can't consent yourself. And I kind of remind people of, when you're a kid and your parent / guardian signed off on all of your doctors' appointments and treatments, it's the same type of thing. If you can't make that decision yourself, you're appointing someone to make it for you. So, it is, and that dynamic is reflected in the situations that we see and the clients that we see. It can be very confronting to think about your old age and how vulnerable you will potentially become. You're not always vulnerable. And I want to kind of go through some things that we can do to make ourselves less vulnerable and mitigate that risk of financial elder abuse. But yes, it is it's a dynamic that switches, and that can be hard for both child and adult to kind of grapple with.
Absolutely. So, who can you actually appoint as your attorney?
So I often look. The vast majority of powers of attorney are people appointing their adult children. They don't have to appoint their adult children, though. You can appoint. You can appoint friends. You can appoint other family members. You can appoint trusted advisors, but that you would prefer. You would need to talk to someone about that first. You don't just appoint your accountant without asking them first about it. But essentially, they need to be an adult over the age of 18 at a bare minimum. There's other considerations to think about, though. So when you're just thinking about the people that come to mind, I often say to people, think about who. If you're thinking about your adult child, maybe you're thinking about your eldest. Is the eldest actually the best person for the job just because they're the eldest? Or is the youngest actually the most type A, the most responsible, the most organised? You have to kind of think about the practical personality traits. Are they type A? Because that can help. And it can help people stay on top of things. They have to keep accounts. So someone who's diligent with account keeping and not afraid of an Excel spreadsheet and not afraid of keeping things tidy and organised and accountable to the family and to all involved, because it is a fiduciary document. It's a fiduciary duty, which means that they have to act in their best interests. The other thing to think about when you're appointing your attorneys, and you're classically looking at these adult children, is are they good with their own money? Are they hyper organised and financially knowledgeable and aware? And again, have they been bankrupt before? Are they also the type of person who you trust them and you know that they would do the right thing, but are they easily influenced? A lot of the time people want to appoint their adult child, but their partner, so the daughter-in-law or the son-in-law, is they don't like them and they're worried about their financial circumstances and they're worried about their influence over the child, and therefore the child maybe having them in their ear saying, oh yeah, but you've got mum and dad's attorney. You can just take that to the bank. We need some money to pay the bills, or what about that holiday that we always wanted to go on? We've got, no one's going to know. And suddenly, they've got undue pressure in their ear, which is a very serious concern. But at that point where the principal, so the client that I'm advising, when they're putting these documents in place, you have to kind of think about not just the fact that they're your adult child or they're your eldest. You have to think about a number of factors to try and mitigate that risk of financial elder abuse in the future. And this is often, you're doing a document maybe in your 50s. It isn't used until 2-3 decades later. And so your circumstances can change in that time too. So it's not a one size fits all, and it's not something that you set and forget. You do set it, but you remind yourself every 3 to 5 years to check in on yourself and to check in on your appointed people and what their circumstances are like. Sometimes it's the case that maybe your type A, very organised child who is your attorney 10 years down the line, they're going through their own marriage breakup, they've got young children, they've got a health issue, and they just don't have that capacity to also be their parent's attorney. And you have to kind of have a think about that too. So yeah, it's not a set and forget.
Absolutely. I mean, let's face it, we all have family arguments. So there could be a family argument, go, you're out of my will, or you're out of my power of attorney, or something like that. 99% of the time just joking. But yeah, don't just appoint your children on their own. And that's another point I think as well. You can have more than one person acting as your power of attorney together.
Yes. So the main other kind of guardrail that you can put in place is that you appoint more than one attorney and you consider the dynamic between the two to three, really, attorneys, how they can be appointed. So you can appoint them jointly. They have to act together. And I'll just use the example of two people. So you can appoint, say you have two children, you can appoint both of them. They have to act together. They have to all sign off on documents, transfers, etc. And banks will have things in place, mechanisms and security measures in place to enable joint attorneys to sign off on things. And they make it as easy as they can within the parameters of making sure that vulnerable people in our community are protected. So the banks are often they're the first line of call. We advise you on who you should appoint and talk to you about that and get the document signed. But after that, we're not the bank. We don't see the attorneys using the document per se. So yes, you can appoint people jointly, but sometimes we just see clients say, oh, but it's easier if I just appoint one. It's easier for this one son to be my attorney because it'll be easier for him to go to the bank by himself, or it'll be easier for him to access my money myself. I don't want him to have to bother his sister. No, there are systems in place. They are there to protect you, and they're a very good idea to put in place and to think about appointing more than one. And going a step further, you might want to appoint more than one. Say you appoint your son, and you also appoint the accountant or the family friend, the maybe not the sibling, but the aunt or uncle or another person in your life who is also trustworthy, and you would appoint in that role, and just, again, put a bit of accountability between both of them. You can appoint people as jointly and severally, which means that one could act severally. So one could act without notice to the other. That provides some flexibility and it works for a lot of people. But when I'm thinking about mitigating the risk of financial elder abuse, a joint appointment is best, because it means that one person can't go off and transfer $10,000 out of mum's account into their own account without notice to the other. It can't happen, and the banks won't let it happen. People do try and get around it, but it's a good idea to appoint, to maybe think about maybe appointing more than one when we're looking at it with this lens of mitigating that risk of financial elder abuse. That's a big one. Appoint more than one.
Yeah, and I think that's the thing. You don't want to be influenced by one adult child. Oh, I don't get along with my sister or whatever or what have you. Well, too bad. That's probably not such a bad thing.
Yeah, it's a fine line, because you do want it to be effective and you don't want it to stall, and you don't want, you want bills to be paid ultimately. Yeah. You want it to be effective. But it's good to think about not giving all of that power to one person.
Cool. Okay. Are there additional powers you can add to an attorney? And do you recommend these, like gifting and what have you? What's your thoughts on that?
Yeah. So my default is no gifting. That's kind of the base position that I have when I'm advising clients.
What about a cup of coffee and a donut? Come on.
Yeah, I still think the attorney should pay for their own coffee and their donut. But look, in the lens of New South Wales documents, there are additional powers that you can implement in the document. So there's three main ones. The first power is a gifting power, just an open gifting power. So it means that you're granting your attorney to be able to give gifts to essentially anyone. That could be birthday gifts, that could be donations sometimes, things like that. The second power is the ability for the attorney to confer reasonable, keyword reasonable, living and medical expenses on themselves. So say if the the principal appoints their adult son. The adult son could get access to mum's money to pay for their electricity bill. So that's one. It's reasonable living and medical expenses. Then the third is, again, conferring benefits, reasonable living and medical expenses on, A, B, and C. So you name those specific people. If I'm going to include any of those three powers, it would normally be that last one, because normally between a spouse, you would want to include that, because it might be that the electricity bill is in my name, but all the bills money that pays for all of that just happens to have always been in husband's name. So it's just easier to kind of cover that off between spouses. But going that step further, that's where you kind of talk to your lawyer about who is dependent on you. Who do you make regular transfers to? Are there any regular donations that you're making? And you can cater that power. You can make that gifting power, for example, subject to conditions, and you put limits on it. So and that's where that legal advice comes in, because we find that, well, the statistics show that people have been signing these documents without legal advice, and that might mean that they're just ticking those boxes and saying yes to all of them, giving a bit of especially that first power, giving the attorneys the ability to just access the money and say, yeah, mum wanted to gift me a Lamborghini. I was like, well, that's not how that works. So that's unfortunately that risk. So there are those additional powers that you really need to consider, and whether they suit your circumstances and how you can cater them to your circumstances. The other power that in Queensland you can do is you can appoint in Queensland there's a reporting power where you can appoint the Queensland public trustee to be a reporting entity. So you're binding your attorney to have to report to the public trustee on certain transactions every year, for example. That requires them to do all of their proper accounting, which they're supposed to do regardless of the reporting, but they have to report, and it kind of forms, again, a bit of accountability. And so that might be something that I would advise clients to use when they're just appointing one attorney, because it turns out that they only have one person that they trust in that role, and in their circumstances, they're the best person. But then that's another way of having a bit of accountability for that one sole attorney. Instead of appointing two, you can appoint one, but make sure that they have a reporting duty to the Queensland trustee.
Thanks, Julia. Generally speaking, what do you advise your clients when discussing the risk of financial elder abuse?
I always talk to them about keeping open communication with their family and with the people that they're appointing. They have normally already done the hard yards in calling a lawyer and preparing their estate planning documents. That can be quite daunting on its own. So they've done the hard yards with that. They've spoken to the lawyer about their family and their financial circumstances and their beneficiaries and their family members' circumstances and why these people may or may not be right for each role. And that's a really important conversation that they're having with an independent person giving them advice. But we don't give life advice. And we just encourage them to have conversations with their family members. We can often facilitate those meetings, but a lot of the time people just need to maybe have a nice family dinner, over dessert, be talking about, oh, well, I went to see my lawyer, we went to see our lawyer about our estate planning. And then that opens up the conversation about what they know about the documents that they've put in place, and then also what their children know. Their children might also know what the documents are. They might be aware of them from their own community and, friends or family on the other side that have come across these issues. So it's important to raise everything together and talk to each other. Those conversations are just very important, and they can, when it is brought up in a light-hearted way and it's not in the midst of, say, a death or a disaster in the family, it can turn quite funny quite quickly. You can make jokes about death. It is a well-known area that you joke about, and that's okay. You can approach it lightheartedly, and just talk to your family in an open way about what you've done and why, and any concerns that they have, and just keep that communication open. The second thing I would say to clients as they age is do your very, very best to stay on top of technology advancements. It can be very, again, daunting to keep informed and keep knowledgeable about they're so fast. Things change so fast. But if you keep up with it yourself and you take that responsibility on in making sure that you know how bank transfers are made. If you primarily go to the branch, and that's fine, the branch is still open, the branch will still make that transfer effective. It is also important, though, to know that you could do this by phone, you could do this by internet banking transfer. There's also third-party apps that affect bank transfers. It's important to know about these things to give you independence and give you independence and peace of mind about your own finances as you age, so that you are not totally reliant on your children to do very basic tasks that you have the capacity to do. You do know how much is in your bank account. You know that you need to pay this bill. You know how much you need for groceries. But because you've just kind of given over that, you haven't stayed on top of how things are done in the community by way of bank transfers is a big one. Suddenly your child or your grandchild often is the one making these transfers for you because I don't know how the internet works. I don't know how to do that. I've always done it in the branch, and now there's only one branch in my whole 50-kilometre radius, and I can't get over there, so now I don't know how to make a bank transfer. When you have the capacity to do it, but you have just unfortunately been left behind with technology, and you're not taking responsibility for that fact, and that has happened. And that can also cause loneliness and isolation as well, and that's not nice when you're growing old. You want to maintain as much independence as possible. So I try to make sure that message is across with my more elderly clients to keep on top of it yourself, go to the Apple store lessons, and don't get so relaxed about things, because it can suddenly advance, so many steps ahead. We're not doing phone transfers anymore, and there's these third-party apps, but you're still at the branch or you're still doing phone appointments. And so it just can advance so quickly, and then suddenly you're not the one doing any of your bank transfers, and you're not the one paying bills, and you're not getting cash out because of just technological movements and advancements that you've not stayed on top of. And that can suddenly make you quite vulnerable when you didn't need to be. You didn't need to be vulnerable in that way. You might be vulnerable in other ways that are out of your control, but not in this one. So if there is something that you can control, it's knowledge and engaging with the community and how things are done and how those technological advancements progress.
Well, if nothing else, be able to log in and check your account balance.
Yes, that is a very good one to start with. These days, trying to get a bank balance by mail or whatever, you can forget unless I want to charge you for it or whatever. All those things no longer exist. Getting a phone bill in the post doesn't happen anymore. So just make sure you know how to do it. Okay, look, thanks, Julia. Thank you for that. Can you just give us a quick wrap up, please? So, in summary, when you're looking at these documents, like the enduring power of attorney, when you're looking at it within the lens of mitigating the risk of financial elder abuse, you have to know what the document is, know what the document can allow your attorney to do, any additional powers that you might want to be considering either catering and amending or just not including at all, and knowing what those powers are and making sure that you consider them properly. And who you appoint and how you appoint them. It's very important consideration. These are documents that people use to get access to their parents' money and steal mum's money, steal dad's money. They are very, very important. So you really have to put that level of care and consideration into them when you're doing the document, and that's where the legal advice is very crucial. And yeah, think about any additional powers like reporting for Queensland in particular, and keep communication open and keep on top of technological movements with banking, and banking moves very quick. And I think Australia is quite unique in that regard. I think we move quite quickly with that. So they're the key kind of factors, and just think about these documents. They're very, very important. When you need them, you need them. And yeah, I think it's just important to go see a lawyer about them and make informed decisions.
I think that's the key thing, is making informed decisions.
Yes.
All right. Thank you, Julia.
Thanks, Tony.
Thanks for listening today. Don't forget to subscribe, and if you require any further information, please go to our website www.degroots.com.au and book a consultation. The contents of this podcast do not constitute legal advice and are of a general nature only. Listeners should make their own inquiries about their specific circumstances and seek legal advice.